Intra-party conversations are intensifying across the political terrain with the irreversible approach of the 2023 elections, all things being equal. Again, for the upteenth time, much of that conversation centers on youth and leadership. What must Nigeria do to finally achieve a transition of political power from today's leaders to a more forward-looking, technology-savvy, science-believing generation? Perhaps the country's current struggle with COVID-19 may have gone some way in providing answers. With thousands of Nigerian lives in constant peril as the virus continues to flatten everything in its path, and with the prospect of many years of picking up the pieces ahead, what manner of leader must Nigerians elect in 2023? Joining us now from Washington, D.C., United States, to take a look at this matter of great public interest, and of course, a number of key developments in the polity is Daniel Bwala, a lawyer and member of Lincoln's Inn, London. Welcome to the program, Mr. Bwala. Thank you for joining us. Good morning.
Good morning, Tudun. Thank you for having me.
Daniel Bwala, good morning. Well, I hear you are in Washington, D.C.
Yes.
I hope you are keeping safe. But very quickly, let's start with something that is topical. At least 6 states in the northern part of Nigeria have had to shut down schools, boarding schools, public schools, private schools, on account of this incessant focus by bandits and terrorists on schools, attacking schools, abducting students at all levels. Do you think that the closure of schools, even if they say until further notice or for 2 weeks, is the solution to the problem of lack of safety in Nigerian schools in key states of the north?
The closure of school actually exposed the weakness of government, their inability to provide security for the schools. And I remember when the Chibok girls were kidnapped at the time, there was a conversation around saving the school. And I think the United Nations also played her part through the agency of the UN to ensuring that the climate and the environment where pupils and students undergo their studies should be protected in such a way that it will not, the situation of Chibok girls will not repeat itself. But just like in the case of COVID-19, after the advent of COVID-19, you would have thought when big politicians in Nigeria could no longer travel abroad to get medical attention because the entire world was locked down, you would have thought that the government will take that. When I'm talking about government, I'm talking about federal, state, and local. You think that they will take that as a lesson and then begin to build world-class healthcare facilities. But nobody has learned this lesson. So it's the same way in the schools. And that clearly has fed into the narrative of Boko Haram. Boko Haram from the get-go said that Western education is forbidden. And that one chiefest goal that they have is to ensure that they diminish Western education first and then dethrone the government second. While they have not dethroned the government, as it were, they have been able, at least in the Northeast, and now it's even moving to the Northwest and North Central, they have been able to achieve one aim, which is that they will ensure people do not have thirst, people do not have the desire, and people do not have the security of going to school. Unfortunately, in the entire northern Nigeria, apart from Borno State and Kaduna, that I know have taken bold steps in ensuring that education is given priority in the policy of government. The rest of the northern state, I do not think they've learned the lesson. I do not think they even care about it. Dr. Babati, if you see the pictures of quote-unquote primary school and secondary schools in the north, you will weep. And these are the same environment where people who are in public office have gone through in their times growing up. But nobody seems to have paid attention to that. If I have my child and I live in a rural area, I will not let them go to school because I would rather have them at home and teach them myself than to let them go and die like that. But honestly, this has exposed the weakness, inability, and poor leadership that we have in Nigeria.
It's a crying shame that it has come to this, but I'd like to move on to another topical issue. The crisis rocking the Cross River North senatorial by-election has generated a lot of confusion because of the Supreme Court judgment. What's your take?
Interestingly, the Cross River scenario has clearly also brought to bear 2 major issues, one of which is the conflicting orders of court, which sort of confuse the people more than the solution it seeks to provide. But much more than that, it also called for the reform of electoral process. I'll give you brief facts of the matter. There was a by-election conducted in Cross River. Senator Stephen Ode emerged the winner beginning with his party's primary, which is the PDP. And the pictures and the videos are there all over. He emerged the winner, and then in compliance with the provisions of the Electoral Act, he proceeded to do documentation with INEC. The other fellow, Jaribe, who lost, now begin to go from one court to another. What we have been crying against, forum shopping, seeking for taking the mandate of the people through the back door. Now, he filed multiple cases in court. He lost all of them. On the eve of the primaries, the court cleared Stephen Ode. He went into the primaries, won the primaries, went into the election proper, and he won with a clear court victory, defeated the APC candidate at that election. He proceeded to the Senate and was sworn in as the senator representing Cross River North. Now, this fellow went to High Court in Calabar, in Port Harcourt, lost all of the cases, went to Court of Appeal, lost the case again. Now decided to go through the back door by instigating someone to sue him in a High Court in Abuja. Talk about the issue of jurisdiction now, because the matter started in Cross River. For reasons we don't know, they went to High Court. The person who sued Jaribe on the account that Jaribe falsified document, didn't have certificate, all of the noise. But the court declined jurisdiction to determine the matter, but made a consequential order, which has now created a legal problem, because how could you in one breath decline jurisdiction to hear a matter and in another breath make a consequential order that the person should be accorded all the privileges of a member of a political party? In any way, that order and giving him the privileges cannot translate to declaring him winner, because the Electoral Act is clear. For somebody to emerge as a winner, first there must be a declaration of result, and then INEC will be ordered to give him certificate of return. Now, assuming you come to the court and somebody, let's say Stephen Ode is there as a winner, but Jaribe wants the court to collect that victory and give him, we know the Trinity prayer that must be in all pre-election matters where somebody is challenging the candidacy of a party. Number one, if INEC has issued you certificate of return, the court will make an order invalidating the certificate that was given to you. Secondly, the court will make an order declaring you as the authentic candidate or the winner, as the case may be. And thirdly, the court will make an order for INEC to issue you a fresh certificate. If you do not find this Trinity or Trinity element in any declaration of court, what you have gotten is a consolation. It will never amount to you assuming. Now, when he got that, the party went to Court of Appeal on the same matter, and Court of Appeal sustained that order that he should be accorded the privileges. He now started parading that order as though he has been declared as a winner. Now, Stephen Ode, this is the part that is very interesting to do. Stephen Ode, knowing that he was not joined in the High Court, he was not joined at the Court of Appeal in that kangaroo activities that they were doing, decided that, okay, even though I'm a winner, I'm in the Senate, but where an order is made that I feel might affect me, let me seek to be joined. First of all, the law is that an order cannot bind a party that is not joined in the matter. And they didn't join him in the High Court, didn't join him in the Court of Appeal. But he applied to be joined, and he was granted the leave to join. Then he filed a notice of appeal to the Supreme Court, challenging the order, the decision of the High Court and Court of Appeal. At the Supreme Court, Jaribe brought a notice of preliminary objection challenging the hearing of the appeal on the ground that the address of service was not proper. The Supreme Court sat down in a panel of 3-4 split decision, now held majority, that going by the rules of court, service of address of a service is fundamental. And if a party fails to do that, there is no way his appeal will be determined. So Supreme Court now struck out the appeal on the ground of want of address of service, not on the substance of the case. Jaribe took that one and got all the media in the world to tell them that Supreme Court has dismissed Ode and granted him a judgment. That conundrum created a confusion right from Court of Appeal when INEC erroneously issued Jaribe with a second certificate. Where there are two competing certificates, the rule of law is that the first one in time prevails. Where there are two competing equities, the first in time prevails. Where there are two competing titles, the first one prevails. And in any case, the second title was issued in error Because if you did that on the consequence of the order of the court, the order did not ask you to issue certificate. The order say you should accord him the privileges, in which case he has not even participated in all the stages of election that will give him the legal eligibility to be declared a winner. So 3 major problems. Somebody who has not participated in all stages of election cannot be declared a winner. Number 2, an order that is not very express, definite, and specific cannot bind a party, or a party cannot benefit from it. And thirdly, every activity that is outside of the provisions of the Electoral Act cannot be sustained.
All right. A lot has been said about this case. It's been back and forth. And this brings me to the question about even the rule of law, and can I call it the rule of lawyers? What does this mean for our polity? Yes, because all of this movement and action taken is the lawyers that are advising, back, and they are doing their machinations as regards, to serve the purposes of their clients. So this contestation between the rule of law and the rule of lawyers and interpretations here and there, what does this mean for our polity?
In England, thankfully, I've been admitted to practice in England. In England, although I'm not practicing there, but in England, they have a procedure that if a lawyer or a party files a matter in court, but the matter he files is obviously frivolous, right from the registry, they will not accept it for filing. It won't even get to the court to begin to determine whether it's an abuse of court process. Then secondly, if a lawyer proceeds further after losing the matter and goes to the Court of Appeal and files an appeal, and the appeal is defective in other words, the appeal you're filing, there is a settled law on the matter, and you should not have even appealed in the first place. 2 things happen. The first one is that the appeal will not be received for filing. The second one, that lawyer will be referred to disciplinary committee. But in this case, you don't know what exactly the client breached the law, because another conundrum is that if a lawyer is instructed by a client, your duty is to advise him on the strength and weakness of his case. After you have given him the advice, if he chooses to say move on, you are bound by the rules of professional conduct to just proceed and represent his matter, except where there is a conflict of interest or there will be a commission of crime. So it is in that sense that you will not blame a lawyer because you don't know if he has advised him on the strength and weakness of his matter. But assuming, without considering that, the lawyer takes the matter, there is another duty on the court. This leads me to the second part that we have been, since 2015, making recommendations, just like the way they do it in England. There should be in court, like let's say Federal High Court, there should be a file the arising system where if Justice Tudun deliver a judgment in respect of a matter, and then Mr. Rufai goes to another court for forum shopping to file a similar matter, right from the system, it will reflect on the judge. And one, they will either not accept that matter for filing, or when they have accepted, on the day the matter comes up, the court will just dismiss it because you are trying to bring the heads of judges together. But now what we find in pre-election, in election, outside of election, conflicting decisions by court of coordinate jurisdiction because one decision does not bind the other. So it is a matter of administration on the part of the judiciary that the only way we can bring sanctity, to the system is for us to begin to frown at this idea of forum shopping. But if you permit me, Dr. Abati, just to say this.
Unfortunately, Daniel Bwala, we need to take a short break. But when we return, I'll try to make an attempt to bring it down to the level of our viewers so that this is not all legalistic discussion. But we'll take that break and we'll come right back. Please stay with us. Welcome back to the morning show here on the Arise News channel. Our guest is still Daniel Bwala, a lawyer and politician, talking to us from Washington, D.C., the United States. Yes, Daniel Bwala, you were going to make a point before I said let's go quickly for a commercial break. But you can conclude on that point and then go a step further. Right. I would like to ask you, look, this Ode Jarigbe case that you've been talking about, this looks like a pre-election case, right? And that case was concluded only last week by the Supreme Court. Now, the 2019 general election was concluded long ago. Apart from a case like this, we have similar cases that continue to go on almost interminably. 1 year, 2 years, after the election. But I recall that at the time, there was some advocacy that, look, election cases should just be concluded expeditiously so that everybody can concentrate and that the people who are being represented can get the benefit of their franchise. Do you think that this is something that the National Assembly really needs to worry about this time, to amend the Electoral Act accordingly, so that these election cases don't just go on forever? Over to you.
Right. This is a work in the Electoral Act is a work in progress. And every election cycle, Nigeria is a wonderful country. Every election cycle, there will be a new emerging threat to the electoral process by politicians. They kind of find a way of going around the wheel. But I know for sure, for example, the Deputy President of the Senate has even proposed a constitutional amendment. Now, this is an amendment from the Constitution, from the ground norm. Then it will have consequential effect in the Electoral Act. And they are twofold. Number one, matters of executive or political party. You see that sometimes there will be a primary. It will begin with even Congress. There will be Congress. Then you will hear there are two sets of executive that emerge from the Congress. One is original. The other one is fake one. But they will continue to operate. Then from Congress, there will be primaries. A candidate will win, go to the election and win. He will be sworn in whatever capacity, president or governor or senator or House of Rep member. While he is in the House, this Congress, the faction of the executive that came out of the Congress will sue. A candidate, they will hold their own quasi-primary, somebody will emerge, and then they will come to court and tell the court that that person who emerged from the authentic ESCO was not the right person. And then you see somebody who has never, is like reaping where you have not sown, who has never taken part at all, becoming a clog and disturbing the smooth operations of that elected officer. So we have now proposed a constitutional amendment that would take away the jurisdiction of the court at all from hearing dispute arising from party affairs. In other words, we are restoring Onowa's case. Whatever the party decides is final. That is one breath. So this High Court of FCT or the Federal High Court or any High Court of the state will no longer have jurisdiction to determine dispute arising from Congress. Then another step further is we have now provided for the amendment of the Constitution and the Electoral Act that will provide for total termination of pre-election case before election. You see, there are time periods. Sometimes pre-election matter comes, somebody emerges winner, the other one is aggrieved. He haunts you even after the final election. By the new amendment, it means that if after your primaries you are aggrieved, you go to the court, you go to Court of Appeal, right up to Supreme Court. The time we are providing is that all of this dispute must be decided before the main election, so that whoever goes into election knows there is only one devil to face, which is the opponent. And if he wins, then it is only election tribunal. That way, we'll be able to deal with this kind of scenario that you see in Jaribe's case, where people go around every court foreseeable to get order. That is the third part. The third part is we are proposing the creation of, just like the way you have election tribunal, there will be pre-election tribunal, so that there will be expedited hearing of pre-election matters so to the point of conclusion before the final election. This innovation, I believe, will bring sanctity to party executive activities. It will bring sanctity to pre-election matters, and we will be able to deal with election tribunal from a clear-cut understanding of the rules of engagement, so that you will not be fighting two devils, the devil from the House and the devil after election. Because now all of this battle that Senator Stephen Ode has faced with Jaribe are just family matters. Then there is another devil of facing tribunal. And that is never good for the polity, because an elected officer that goes into office will not be able to concentrate. It is the very reason why Section 308 was put in the Constitution, so that governor, deputy president, or vice president will not be distracted from performing the function. In this case, all other public office holders who are not covered by immunity have another vulnerability, which is that congressional matters, pre-election matters can disturb you and affect your good operation as a public office holder.
And speaking of party decisions, it's been reported today that a panel set up within the People's Democratic Party to investigate why they lost the 2019 general election has decided to jettison zoning entirely, and instead they're suggesting that it should just be purely on the merits, who gets to fly PDP's presidential flag. What are your thoughts on this?
I think PDP is trying to be strategic. It's not about zoning. The PDP is a little bit confused because, what I mean confused, not in a denigrating sense, but PDP is beginning to come to terms that APC has not yet decided whether they are zoning the power to the southwest or that they are zoning power elsewhere. Because if PDP takes a bold step, for example, to say, well, zoning the power to the southwest, and APC produce a candidate from another party, it can change the calculation. So that was a deliberate decision, I believe, by PDP to wait until APC is able to decide which zone of the country they are zoning so that they can match them. So assuming the APC zone the power to the southwest, then they will make a determination to produce a candidate from the southwest in order to match the candidate from the southwest. If the candidate in APC emerges from the north, then they will produce a candidate from the north in order to match the person from the north. Because the Nigeria is so polarized that when you have from these two big political party candidates from two regions of the country, it is going to be, how do I even put it? It's going to be self-predicting, because of numbers. And then the fact that, it will breed crisis in the country. So it is strategic. This merit thing you are hearing PDP saying, forget about merit. They already know who and where they are going to vote.
Daniel Bwala, just a point of correction. The PDP, according to the report, has not yet taken a decision. The recommendation came from a committee that was led by Bala Muhammad, the governor of Bauchi State. And what Uche Secondus, the chairman of the party, has said is that the party will look at the recommendations and take an eventual decision. But I get your point about strategy.
I would have been surprised if there was no swift point of correction there.
All right, the swiftness of that and all of that going on. But real quickly, Daniel Bwala, I know we're pressed for time, but I just want to prick your brain on this real quickly. What will you say about what is currently going on as regards the agitations by various groups? There was a flag hoisted yesterday. The Eastern Security Network are saying there's a pro-IBOP people. It's just keg of gunpowder everywhere, a lot of agitation. What would you say about that, briefly?
Well, this comes down to leadership. It is how you manage. All over the world there are crises. Nigeria's own is peculiar because politicians have over the years created the division, and every day it keeps going. It is what the president does that matters. For example, he has to engage. He has to have his emissaries that will engage with various parts of the country with a view to bringing them together. A lot of people in the appointment of Mr. President are redundant. They are ineffective. They do not have idea. I'm just being honest. There's no point pretending when we're losing lives every day. Even in the area of security, let me just give you my plain opinion. The president rejigged the service chief by removing the service chief, but he left the national security advisor. And the national security advisor ought to go with them, because look at what happened recently when he made a statement that indicted the previous service chiefs. But little did he know that statement also indicted him, because as a national security advisor, you can't claim not to know what happened at the time, but you're coming with it because people believe it's a vendetta.
Daniel Bwala, thank you very much indeed for joining us this morning, and we hope you enjoy the rest of your stay in the United States.
And go to bed. It's like 5 a.m. over there. Go back to bed.
Honestly, you guys woke me up from sleep.
Thank you very much.